Across the European Union, abortion rights are both a reflection and a cause of heated social and political debate. While the EU is often seen as a bastion of liberal democracy and personal freedoms, the reality of abortion access is a patchwork shaped by national histories, political climates, and evolving social attitudes. The right to terminate a pregnancy is recognized in some form almost everywhere in the bloc, but the scope, ease of access, and barriers to care vary dramatically from one country to another. To begin to understand the state of abortion rights in the EU, we have to recognize that these laws are largely the prerogative of national governments. The European Union, as a supranational body, has little direct say over national abortion policy. There is no legally binding requirement for member states to legalize or protect abortion, nor even a shared definition of reproductive rights. Rather, the EU defers to each country, and the result is a striking range of policies. Let's start at one end of the spectrum, in countries where abortion rights are most liberal. Take the Netherlands, Sweden, and France. In these countries, abortion is available on request, typically well into the first trimester or even beyond. In the Netherlands, for example, abortion is legal up to 24 weeks of pregnancy, although it is rare after the first trimester. The process incorporates a mandatory 5-day waiting period, but within this structure, access is comparatively broad. Sweden permits abortion up to 18 weeks on request, after which permission is required based on medical or other serious grounds. France legalized abortion in 1975. With access until 14 weeks of pregnancy as of 2022, the procedure is performed either surgically or with medication. And while some bureaucratic hurdles exist, these countries actively work to ensure that access is safe and generally available. Now move to the other end of the spectrum, two places where legal access is notably restricted. Even among these, Malta stands alone. Malta is the only EU country to entirely prohibit abortion under all circumstances, a position enshrined in both legal code and the country's constitution. Women and doctors face potential criminal prosecution for performing or undergoing an abortion. There are no exceptions enshrined in law, not for rape, incest, severe fetal impairment, or even to save the life of the pregnant person. In practice, doctors do sometimes intervene in life-threatening situations, but they must carefully weigh the legal risks. Poland is another prominent example, having moved in recent years towards further restriction. For decades, Poland permitted abortion in cases of rape or incest, threat to the woman's life or health, or severe fetal anomalies. But in October 2020, Poland's Constitutional Tribunal ruled that abortions for fetal abnormalities were unconstitutional, effectively banning nearly all legal abortions. Today, abortion is allowed only if the woman's life or health is at risk, or when the pregnancy is the result of a crime. Even in these circumstances, access can be extremely difficult due to medical providers' refusals and bureaucratic delays. This legal move sparked widespread protests and drew international criticism, but the law remains in effect. Between these extremes lies a broad middle ground, with different states charting different courses. In many countries like Germany, Italy, and Belgium, abortion is available, but only under a set of defined circumstances or restrictions. Germany offers perhaps the clearest example of this balancing act. Abortion is technically illegal under the German Penal Code, but remains unpunishable in the first 12 weeks of pregnancy if the woman undergoes mandatory counseling and observes a 3-day waiting period. After 12 weeks, abortions are permitted only for compelling medical or psychological reasons. The system is designed as a compromise, reflecting both the legacy of Catholic and Protestant moral teachings and the demands for personal liberty from Germany's post-war generations. In practice, abortion is available, but certainly not on demand. Italy's case is singular in another way. Abortion has been legal since 1978, but only in the first 90 days of pregnancy and following a mandatory consultation aimed at exploring alternatives. After 90 days, abortion is possible only for medical, fetal, or psychological reasons. But while the law establishes the right, practice is sometimes another matter. In recent years, about 2/3 of Italian gynecologists have exercised their right to conscientious objection, refusing to perform abortions on moral or religious grounds. This has meant that in some regions, abortion is available only in theory, not in practice. Belgium, on the other hand, legalized abortion relatively late only in 1990. Today, it is available up to 12 weeks, after which it's permitted only in cases of serious danger to the woman's health or fetal anomalies. Belgium, like its northern neighbors, has invested in reproductive health services, but social stigma and regional disparities affect practical access. Several other EU countries, such as Austria, Denmark, Spain, and Portugal, abortion on request in the first trimester, with stipulations on mandatory counseling or waiting periods. Spain liberalized its abortion laws in 2010, permitting abortion on request up to 14 weeks and for certain indications up to 22 weeks. However, regions operate semi-independently within Spain, and the availability of services can differ between, for example, liberal Catalonia and more conservative regions like Castile and Leon, Portugal, once one of the EU's most restrictive jurisdictions, held a landmark referendum in 2007, legalizing abortion up to 10 weeks, with a short waiting period and required consultations. In some EU states like Hungary, Slovakia, and Croatia, abortion is available up to 12 weeks, but only after formal counseling, mandatory waiting periods, or permissions that serve as practical deterrents. Hungary's laws require pregnant women seeking abortion to attend to counseling sessions separated by at least 72 hours. In Slovakia, lawmakers have debated tightening access with proposals for mandatory ultrasound viewing or seeking the father's consent, but so far, the core law remains as is: abortion available up to 12 weeks on a woman. It's request, but with bureaucratic steps that can delay or dissuade. Across the region, the actual experience of accessing abortion can depend as much on local culture and medical practices as it does on law. Even where the law is liberal, as in Greece, where abortion is legal up to 12 weeks, infrastructure shortages, local opposition, and lack of providers can leave people without real options. This implementation gap is a common feature in the EU landscape: legal rights on paper, but uneven ability to access timely and affordable care, especially in rural or conservative regions. In countries with sizable religious and political divides such as Ireland, the evolution of abortion rights has been intertwined with national identity debates. For much of its modern history, Ireland had a near-total ban on abortion, gaved in its 1983 constitutional amendment. This changed in 2018 when a decisive referendum repealed the constitutional prohibition, leading to new legislation allowing abortion up to 12 weeks of pregnancy, and later in cases of serious risk to the woman's health or fatal fetal abnormality. Ireland's rapid shift marked one of the most significant changes in European abortion policy in recent history. While there is broad consensus in most of Western Europe for at least some access to abortion, public opinion and politics can shift quickly. In several countries, ascendant conservative or nationalist political factions have pledged to make access harder, arguing for pro-life stances often rooted in religious or traditionalist worldviews. Meanwhile, in others, especially among younger, urban populations, abortion is seen as an essential part of gender equality and bodily autonomy. These debates play out in national courts, parliaments, and sometimes the streets. European courts have sometimes influenced abortion rights, though their powers are limited. The European Court of Human Rights, for example, has repeatedly found that while countries are permitted to limit or regulate abortion, once abortion is legal, states have a duty to ensure those legal rights are effective. This means governments cannot impose unnecessary barriers, refuse basic information, or fail to provide services in practice. These decisions cast a subtle but important shadow over national policy and push states toward upholding de facto as well as de jure access. It is also worth noting the permeable borders within the EU. In states with tight restrictions, people often travel to neighboring countries for abortions, sort of quiet cross-border reproductive migration. Before Ireland's legal change, thousands traveled to the UK annually. Polish women now routinely travel to Slovakia, Germany, or the Czech Republic to access care. For those with means, crossing a border may be burdensome, but possible. For those without, it may mean continuing an unwanted pregnancy. Looking ahead, the future of abortion rights in the EU is uncertain and contested. Recent years have shown both liberalization and retrenchment. While the general trajectory since the 1970s has been toward broader access, there is no guarantee that trend will continue unchecked. Demographic change, the resurgence of religious and traditionalist movements, and political flux all play a role. Ultimately, the story of abortion in the European Union illustrates the tension between individual rights and collective values. It's a landscape shaped by law, but equally by culture, religion, and politics. The only certainty is change. As societies evolve, so too will these deeply personal, deeply public questions. The EU's patchwork of abortion laws is less a failure of unity than a testament to the profound diversity of belief, history, and experience among its member states. Access to abortion in Europe, then, is not just a matter of law, but of ongoing negotiation, a test of how rights are balanced, protected, and lived every day.